So for our next session here, the legal department's role is an important one, especially with regard to developing and commercializing disruptive technologies in the fintech space. With so many tech developments taking place, understanding the legal ramifications is becoming even more crucial. Listen to our upcoming speakers who will share insight into how chief legal counsels navigate this tricky field. Put your hands together for the thought leaders, Mark Foster, founder of the law offices of Mark Foster, Dr. Olaf von Ramm, professor at Duke University, Pratt School of Engineering, Mr. Jerry, I hope I pronounce this, Buai, Managing Director of Digital Insights and Risk Management at the FTI Consulting, who will share their views on the Chief Legal Counsel's perspective, R&D, and commercialization of disruptive technologies. Sorry about that, guys, a little tongue twister there. Thank you.
Hello, welcome everyone. My name is Jerry Buai. I am the Managing Director of Digital Forensics at FTI Consulting. I am a certified fraud examiner and testifying expert witness. I have served as a leader in the forensic technology practices at PricewaterhouseCoopers, Ernst & Young, and KPMG. I'm not an attorney myself, but I have been working alongside law firms and the general counsel of corporations for over 20 years. In the past, when I've offered my expert opinion on the misappropriation of trade secret and intellectual property data, I've done it from an outside-in perspective. I've been a quick study on the forensic audit trail information and have opined on many legal and regulatory enforcement matters across a variety of industry sectors, including healthcare. Today's Fireside Chat features a rare opportunity to hear directly from Professor Dr. Olaf von Ramm, widely regarded as the world's most prolific researcher and inventor in medical ultrasound. Our Fireside Chat is a dialogue between Dr. von Ramm and Mark Foster. Dr. von Ramm is the Thomas Lord Distinguished Professor of Engineering, as well as Professor of Biomedical Engineering, and also Professor in Medicine at the Duke University Pratt Engineering School and Duke University Medical School. Dr. von Ramm revolutionized cardiovascular medical treatment by inventing the modern echocardiograph, 4D ultrasound machine, including the application of 3D real-time imaging, or 4D imaging, to ultrasound. Dr. von Ramm's inventions fundamentally improved heart care worldwide by enabling doctors and patients to see real-time video-like images of the heart beating and the blood flowing. To date, more than 1 billion patients worldwide have benefited from Dr. von Ramm's inventions by having 4D ultrasound echocardiographs performed. And while he was inventing and engineering an entirely new medical technology, Dr. von Ramm co-founded Volumetrics Medical Imaging, Inc., VMI. Volumetrics designed, built, and commercialized the first 4D ultrasound system sold to hospitals worldwide. Mark Foster has worked in partnership with Dr. von Ramm for 25 years. Mark was outside general counsel to Volumetrics for a decade. Then Dr. von Ramm and the Volumetrics board asked Mark to come in-house to serve as president, general counsel, and chief financial officer. Mark planned and led and executed the largest global patent infringement and licensing enforcement campaign ever in the medical device sector. At the conclusion of the licensing campaign, Volumetrics had licensed Dr. von Ramm's real-time 4D ultrasound patents to GE, Siemens, Samsung, Philips, and Toshiba, basically the entire medical ultrasound industry worldwide. Mark's leadership produced a substantial financial return to the inventors, employees, outside investors, and Duke University. Mark began his distinguished career as special counsel to the US Embassy, Tokyo, as a high-level Japanese-speaking United States trade policy lawyer and negotiator for the Reagan administration. He's had his office in Silicon Valley since 1988. He is a member of the American Law Institute. We are delighted to have Dr. von Ramm and Mr. Foster with us today for this Fireside Chat.
Here's our story as briefly as I can tell. So after more than 10 years of development, Volumetrics manufactured and shipped 29 of our ultrasound imaging systems to hospitals and clinics worldwide. These were the first ever real-time 3D or so-called 4D medical ultrasound machines. These machines, you're probably familiar generally with these as a user. They produce movie-like images of your heart beating or of the blood flowing through your heart or other arteries, all obviously with a safe, non-invasive ultrasound imaging system instead of harmful X-rays or surgery. After 2 years of negotiations, Philips agreed to buy us for $106 million. Unfortunately, Philips breached the agreement, we think, allegedly, as they say in the movies, and instead purchased the imaging business from HP, Agilent. Volumetrics at that point was forced to shut down, over 40 employees terminated, all of our manufacturing and development processes stopped. We wouldn't sit down. We found lawyers, frankly, who took it on a pure contingency basis, and we filed a fraud and unfair business practices lawsuit in federal district court in the Central District of North Carolina, or North Carolina, as Yankees say. After 3 weeks of trial, the judge said he was prepared to direct the verdict, but that he wanted the jury to do its duty. After only a couple of hours of deliberation, the jury came back, found Philips guilty of fraud, breach of the implied covenant of good faith and fair dealing in contracts, and misrepresentation. And the jury awarded Volumetrics $106 million in damages, which was the agreed purchase price. Then the judge, and I'm sure he had been practicing this, said, trebled for fraud. So we had an award of $318 million and $750,000 additional for prejudgment interest. Faced with that and faced with a potential appeal, we settled for payment of $180 million and took that in cash. Paid off our investors after 12 rounds of financing, paid off our employees, made them whole, paid off Duke University, our sponsor and our partner. Unfortunately, at that time, we thought we were done with litigation. We weren't. We discovered that our patents were widely in use. Dr. von Ramm's patents and our other 21 fundamental patents were widely in use throughout the industry. So we reorganized Volumetrics and were forced to file patent infringement cases against GE, Toshiba, Siemens, and Samsung, and then Philips again. Short story long, we basically ran the table after about as litigious a situation as you can face over more than a decade, with, frankly, losing in no material ways at any stage along the way. We settled with each one of the defendants before trial. So today, we think we had a happy ending, as happy as the ending can be in a litigation situation. Today, we're breaking our presentation down into 4 stages: invention and research, especially at a large research university; development engineering; global clinical regulatory approvals and training; and then marketing, monetization, and licensing, in our case through patent litigation. For each phase, we'll try to make points that are applicable generally to technology development across the board, not only to medical devices. But first, let's see where we were back then. Dr. von Ramm can explain this, and where we are now in the next slide. Olaf?
Yeah. Good afternoon. Good afternoon, everybody. You're looking at what we call T1, Thelmascan, the magic scanner number 1. And that device was created in 1973 and came into clinical use in 1974 and served until the early 80s, at which point it was retired and eventually found its home in the NIH Museum in Bethesda, Maryland. It was the first real-time two-dimensional echocardiograph that used phased array technology to do the scanning. And of particular note in that time was that it was really the first medical device that used a full-blown computer to steer it. In developing a system like that, there's a lot of challenges. They are both from the physics side. How do you actually go about doing this physically? How do you generate the sound? How do you treat the sound? How do you display the sound? How do you process the sound in a real-time fashion? And real-time means a lot of things to a lot of people, but we decided that we wanted to have at least 30 images per second of the heart. And so that you could actually, in a video sort of way, as this one shows here, that's actually a 3D reconstruction of a mitral leaflet in your heart. And one of the big applications of real-time 3D has become the looking at mitral leaflets. And, we've gotten very, very good at diagnosing different kinds of diseases of these leaflets, and also very good at deciding when to replace mitral leaflets. We've also gotten very good at replacing aortic leaflets. And all that medical advancement really has been helped by the development of real-time ultrasound in general. Now, I told you the old system, we had to not only think about how to make and design the actual transducer that produces the sound, but we also had to design the circuitry that goes behind it. We have to borrow some from the military, from the radar technology, to be able to do that. These are old analog systems, but they're digitally controlled. And like I said, real time, it all depends what it means to the engineer and the scientist, because these systems require incredible amounts of data just to control them. Never mind to process the images at the end. That's the easy part. The actual control data runs into gigabytes of data for control. So we had to develop that whole technology as well, and then decide how to display this. And in the analog days, we had to use an imagination and use video cameras that were focused on CRT displays that were common in those days. We also borrowed that concept from the air traffic controllers who have planned position indicator scopes, and we use similar kind of approaches to be able to get enough information onto these displays to be able to have a recognizable image. So just speaking for myself, this was a very exciting time because no one had ever seen images like this. I mean, it was true a discovery journey. When you asked the doctor to look at it, they said, "I don't know what I'm looking at." Well, of course not. We'd never seen images like that before. So it took a while. It took a long time. It took 10 to 15 years, really, for the technology to work its way into mainstream use. And if you have an echocardiogram done today, it's just a standard thing. There are machines in large hospitals everywhere, dozens of them. And they're used in the emergency room. They're used everywhere for all sorts of purposes. OBGYN being, of course, a huge part of that.
Thank you, Doctor.
So
I wonder if we could switch gears for a moment, Doctor. Sorry to interrupt. But Mark, if we could have you take
the podium again and talk about the CLO's perspective. We'll go back and forth from the inventor's perspective to the chief legal officer's perspective, and hoping we can keep pace with the content that we have here. All right. Thank you, Doctor.
All right. Thank you, Jerry. You're a tough taskmaster, but we appreciate it. Well, the chief legal officer, we're really busy trying to keep up with Dr. von Ramm and other inventors, not only in the medical field, but other technology fields. First, I just want to allude to the challenges of peeling off technology from a major research university. So I'm in Silicon Valley. I've been dealing with Stanford University for almost 40 years. But believe me, the methods and the systems internally that Stanford have and that Duke have are head and shoulders more straightforward and simpler than the methods that we face with peeling off new technology from other research universities. So the first step that we'll need to take as chief legal officer of a new entity, and we already did form our entity, right? Because we have nowhere for it to go if we didn't form our entity already. The first step we'll need to take is understand what the system is to get that technology from the university, from the inventor who's already assigned it to the university, to our commercial entity. And that's a non-trivial task. Second, we need to protect it. So I've presented here what I usually refer to as my chart for the level of protection of intellectual property, from low being on our left to high being on the right. The lowest level of protection is a very typical mutual non-disclosure agreement. Why do I say that's not very much protection? Because it's a litigation trap. Why would I want to protect the other side's intellectual property? In the first place, why would I even want to receive their intellectual property? So we tear those up almost every day when we're given those by clients or when we're given those by the other side. We don't want a mutual NDA. Is there a place for them? Maybe, but you have to convince me of that. We use unilateral non-disclosure agreements. Next, a step better towards protecting IP is a non-disclosure and a non-use agreement. Very useful. Better than that, and something that we have everybody who touches our IP sign, is a proprietary information, confidentiality, and a pledge to protect agreement. Hopefully, it's even one step better, and it includes an assignment already in there. That's just one step less secure than the highest form of protection, and that is an absolute or a clear assignment of the IP to our entity. Finally, on this point, I just want to say a constant challenge and an interesting exercise for us is to always understand and identify the differences between ideas, innovations, and inventions. Ideas and creativity, we love that, but there's no market value placed on ideas. Innovation is also interesting, and it might be protectable if we own the underlying IP. Inventions are protectable, and that's what we're focused on, and that's what Dr. von Ramm and his team have produced over the past 40 years.
Thank you, Mark. Doctor, if we can have you take the podium again and address this next slide around the inventor's role in developing and engineering complex medical ultrasound system.
All right. You know, the concept of invention or innovation is something complicated that you might address sometime. Where does all that come from? You know, and one slide that I had here, which is missing, is is the idea that, the inspiration comes from involvement in a context and in an area of interest. And it's based on the idea that what else could I do? What else could I see? What else could happen if I did so and so? And anyway, you have to then decide, is it possible, in fact, to do such a thing? And that requires a great deal, I think, of knowledge in many different areas. It's not enough to be a good programmer. You have to know the basics. So complex systems are composed of various subsystems, and they may be different areas of knowledge involved in these subsystems. And so you need a variety of different engineers to create these areas. Now, when you're, of course, a basic inventor like myself, you do a lot of this yourself. I'm also a circuit designer and programmer and all the above. But the inventor has to stay, when you're commercializing such a system, directly involved in this, because you have to make decisions along each step. What are the performance characteristics that we're going to have? So the specs are significantly important. The prototype that develops out of this must be characterized very functionally intensively. What does that mean? We need all the performance numbers, because you know that once we start using these devices, we're going to find flaws. And we're going to have to track back to where these flaws occurred and fix them. The machine has to be tested clinically. It's hugely important. Does it perform as our vision that we had in mind? Does it do that? And we need that clinical feedback, because the clinician may want other features on the device that allows him to use it more effectively. Mark?
Mark, if you can address the CLO's role during development and engineering.
I'll do that. Listen, I realize you came to see me, but I wasn't there. Where was I? Where in the heck was my office? Ha, gotcha. It's out in R&D. That's where the real work happens. That's where my office is. That's something I learned from the lawyers and the engineers at Motorola Japan during the 1980s. That's where the work is. That's what we do as chief legal officer inside a technology company. What do we do there? Well, we log and monitor and maintain engineering record books. In fact, I have one in my bag right now. If you need a new engineering book, come see me, because I've got one. It's an official Duke University engineering logbook that we got the other night. Keep that. I want those pages dated, and I will be collecting copies of that before the final exam. Second, I'm drafting and iterating the software architecture. We just don't compromise. I'm familiar with all the theories, the lean startup and the lean documentation and lean architecture. Okay, fine. We'll have a cup of coffee about that. But we are going to have written software documentation, and we are going to iterate it and update it. Third, we're going to have clear written regulatory approvals path, because at least in the medical device field and in some other, even in defense technologies, we're highly regulated. We're regulated even at the design and conception stage. We're certainly regulated at the stage where we're building and testing our prototypes. So this is a constant challenge for the chief legal officer. The end result of this in most technology companies that I'm involved with is patents. So what is a patent? Well, I don't know if we have any certified patent attorneys in the audience? If so, I'll turn things over to you. No? Okay. Now you're stuck with me.
We have one in the back.
Oh, we have one in the back. Well, come on. You can read the script. Thank you. So, the highest art, patent attorneys. So a patent is a grant by a government, the US government or the Japanese government or the European unions, to have a monopoly to make, use, and sell a product or a process for a certain time in a certain territory. Let's quickly understand, all of us, how to read a patent. There are generally 4 parts to a patent. There's the front page, which is a summary of the patent. There are drawings, which obviously show for hardware what the patent is, or for processes, how the process works. There are specifications, and I'm coming back to that because I think that's where we want to spend our time. And then there are the claims. The claims are very technical. That's why God created patent attorneys. They're very technical specifications, and they form the claims form the legal basis for the grant, the exclusive monopoly grant that you're given. We're going to assume, as most of us, we're not patent attorneys. Many of us are not even engineers. We're going to focus on specifications. The specifications are the background section. The specifications are a technical legal document that are the written basis for the rights associated with the patent. They're a critical part of the patent. They disclose the invention in a detailed way to meet your intended business and commercial objectives. In my experience, for us as chief legal officers in technology companies, one of the most productive and value additive ways that we can work is to write and rewrite and improve our patent specifications. The specifications disclose all the relevant details of the invention, again, in exchange for the exclusive right that the government gives you to make, use, and sell that patent. But the specifications are not part of the claims. They do act as a glossary for the patent claims and as a set of definitions. So as with any written work, if we have a good, clear description of the definitions, a good, clear set of definitions, everybody's happier. Specifications, well written, lead to a clear understanding of the claimed invention. But what happens if your intended meaning is not defined clearly in the specifications? Well, again, in my experience, the result could be you're destined to the purgatory of license negotiations or of patent enforcement and patent litigation. Now, a person with ordinary skill in the art can probably glean or understand the generic meaning of the terms that are in the claims, but that understanding may not be and probably won't be what your inventors intended. Having ambiguity, uncertainty, or terms that are readily susceptible to different meanings is the worst possible place to be in patent licensing negotiations, patent enforcement, or patent defense in litigation. You'll end up proving the validity of my secret formula, which is I'm going to disclose to you in a couple of slides on calculating the costs of litigation. On the other hand, when we have clear, detailed, and well-drafted specifications, ambiguity and uncertainty about what the claims mean can often be avoided. Potential patent licensees love great specifications. Judges love great specifications. Juries love great specifications. And chief legal officers love great specifications. We all love great specifications in our patents. for the chief legal officer to love great specifications and to have great specifications leads to my conclusion here, and what is frankly, I think, the optimal outcome for almost all patent disputes, whether in the licensing context or the litigation context, and that is a negotiated settlement. And what I like to do is have a mock trial based on, in large part, reading and understanding those patent specifications, and where we have the ability to engage in that good faith activity and we have clear specifications, my experience is that we end up in a licensing context or we end up in settling the dispute.
Thank you, Mark. Back to the inventor's perspective, Doctor.
Thank you.
Could you tell us the inventor's role in global clinical regulatory approvals and training?
Right. So, once you make the step from being a researcher into actually be inside a company that's going to produce this device, you have a whole new role to play, which is at times not as much fun as being in the laboratory and trying just new things. But can't do without it. So if you're the one that invented the thing, you better start figuring out how other people are going to use it. So you're going to recruit clinicians and go to medical meetings, talk to them, and do presentations of the data that you've generated. And early in my career, I was one of the doctors basically that was examining the patients because nobody else really could do it either. So, so you have developed this interchange with the clinical community that you are also maybe not exactly like them, but a little bit like them. And so you have to invite leaders in the field to conferences or meetings, special meetings, private meetings, to explain the vision of what this could be. In other words, this isn't just one application, not just one application, but in fact many possible applications in the future. So in running a company like this, you need a medical advisory board that shares and promotes, particularly promotes your vision as to what can happen and how you can improve patient outcome. And the part of that, of course, is every hospital, every doctor has a way of processing his patients throughout the day. We call that the clinical flow. And so how in an established organization, as in the medical center, which is usually a very effective and well-organized or group of people, how does this new device fit into their daily clinical flow? And of course, if you're going to produce these machines, you're going to have to be aware and conform to regulatory issues, perhaps in different countries. So that's a big effort that's needed to make sure that you cross your T's and dot your I's for the various regulatory agencies, such as the FDA, the Federal Drug Administration, which also concerns itself with devices. So there are many ways of approaching the FDA, but it is a major effort to get certification. Mark?
Actually, could you comment on this photo that we have up here, Doctor?
Yeah.
Take a look at the screen.
Oh, yeah. Oh. Well, here you see 3 generations of real-time ultrasound machines, real-time 3D machines. And the middle one is the prototype, and I'm a little bit younger there, but not much. And the one on the left is the first commercial model, Model 1, and the one on the right is the second generation model. And those are some of my graduate students in the background that were indispensable, and also as we went forward in applications to the clinic in developing new approaches.
Thank you, Doctor. Mark, could you please tell us what the CLO's role in global clinical regulatory approvals and training is?
And the image of the machine on the right, some of those machines, which were introduced in about 2000, are still in use today, even though the Volumetrics brand name is not viable anymore. And I will just also say, just so that we can appreciate how profound Dr. von Ramm's invention is, one of our clinical, and this moves into our the development of an advisory board. One of the key people in our medical advisory board, Dr. David San, who sadly passed last year, was the world's leading fetal surgeon, performing corrective heart surgery on fetuses at about 36 weeks so that they would be born with normal functioning heart valves. Think about it. This does lead me to the main point that I want to make here, and that is to focus on an advisory board. And this holds true, in my opinion, my experience, with any technology-based company, hardware, software, scientific, pure commercial. It's really never too early to establish an advisory board. We can call it a scientific advisory board, we can call it a clinical advisory board, or we can just call it an advisory board. But we want to set one up, hopefully on a global basis, as quickly as possible. I will say that I have had recently a phenomenal experience of setting up an advisory board for a technology company, not a medical device, another technology, with advisors, for the first time we think, some advisors in Saudi Arabia and some advisors in Israel. So this is why we say, world peace through world trade. So it's exciting. When we form an advisory board, we want to avoid some of the common mistakes. The single biggest mistake that I hear, even from seasoned and veteran repeat entrepreneurs, well-funded, is to misuse the term advisory board when we're talking about board of directors or vice versa, to confuse the role and the function of our board of directors with our advisory board. And the Elizabeth Holmes trial and the situation surrounding her activity in Theranos is a good case in point. As far as I understand it, some of her board members actually thought that they were simply advisory board members. That's a little different matter. So we want to very clearly understand and educate ourselves on that point. How do we establish an advisory board? Well, it has to be in the foundational corporate documents, in the bylaws or the certificate of incorporation or the articles. And I have some preferences. This is actually one of our most popular packages, and we do one or two of these a month. So I do have my own preferences, but we do need to firmly and clearly establish the foundation for our advisory board. Do our advisory board members have a fiduciary duty towards our company? It's an interesting question. Who are they? Generally, probably not. Sometimes, not often, but certainly in my experience, several times a year, we do see the issue of dual fiduciaries, which is always an interesting phenomenon and a tough cat to skin. What do we expect from our advisory board members? Well, we want them to author white papers or more serious academically serious papers, peer-reviewed papers. We want them to make introductions to other thought leaders in our sector. We want them, as I think Olaf alluded to, we want them to help us map out a regulatory strategy and a compliance with the applicable technical standards in their jurisdiction. We want them to be reference accounts for our early sales. We want them to buy our technology in the first place. So at Volumetrics, one of the things that we did, I think, really well and correctly was that we had our advisory board established, and I would say it performed each one of these functions, and I can say with certainty that we would never have gotten European or Japanese regulatory approvals had it not been for the activity of our advisory board members in those jurisdictions. The last point I'll make is, do our advisory board members create protectable intellectual property for us, and how do we deal with that? Well, the answer is probably they do. Sometimes that's dicey because, as I mentioned a minute ago, they probably already have a fiduciary role towards their employer, towards their partnership, towards their university. So we do need to carefully deal with how we protect the intellectual property that our advisory board members are creating. But we'll do that. Thank you.
Thank you, Mark. Doctor, for the last set of, the last topic here around the inventor's role in marketing, monetization, patent licensing via enforcement litigation.
Well, we're at a stage right now, we've got 30 employees and we're actually building machines. And what really needs to be done, and what really needs to be done is to look at the patent situation. People that have been building the machines, working the engineers on developing circuits and software have ideas that are novel, that come out of the construction and development. So these need to be applied for. And particularly, we got to make sure that the fundamental patents, which, you know, in my concept, are the patents that are related to and define the overall structure of what it is we're doing. Not the details necessarily, but the overall concept, how a device works. So, but then we have 30 people and we really need more, and so we need to build a company. And so at this stage, you know, the question arises, you know, how are we ever going to make any money? We could either make money by building the company and producing more, so we need investors, more investors, or we can try to sell the inventions as they are. So, so another role that the inventor, I have to play, is in this business about raising money for growth in the company. So it takes me far away from where I originally started, but it's still the same vision that I then have to give to potential investors. So we need to recruit a management team. If we go on and we get the investors, I need to get out of this business of being a business person and really do have a management team that looks at the business side of things. And unfortunately, as you've heard, there will be court cases regarding the patents. There will be infringements. If you develop something and you sell something, then people are going to say, well, we can do that too. And then you're going to end up in court eventually. So that's, Mark, you want to wrap this up?
Thanks, Olaf. As Olaf mentioned, so there are basically two ways that we can make money from our intellectual property. Okay, either our patents, trademarks, copyrights, trade secrets, right? First, we can make, use, and sell products or apply the processes globally. We can slice and dice the geography. We can make the stuff and sell it. Second, we can license it. We can turn it over to somebody else on an exclusive or non-exclusive basis. Again, we'll slice and dice the world, the sectors, the times, and those two methods of monetization are certainly not mutually exclusive, we might do both. And very commonly in the medical fields, we are doing both. Unfortunately, if we do get into a litigation situation, now I'm sharing and keep this to yourselves, this is a secret. This is my secret formula. I will say, because I work with scientists, that it is scientifically validated and it has been peer reviewed. But again, it's a secret. And that is CL, if we face a litigation situation, bring your CEO and your board members to this formula. CL equals MT to the power of infinity, where CL equals the cost of litigation and MT equals management time. Infinity equals infinity. Or you might, as in Toy Story, you might even go to infinity and beyond if it's really expensive. Why do I say this? And I say this not totally in jest, and that is because in a litigation situation, as we can attest, especially if you're in it for a decade or 15 years, it's really like building a house that you give the architect unlimited freedom and say, I don't care what it costs, I can't be concerned with what it costs, I just need it built. And I need to move in as soon as I can. And that's the way litigation is. So I wish you the best if you get involved in litigation, but I also hope that you settle as quickly as you can on favorable terms. In that context, quickly, I'll allude to the question which is important for us to settle as chief legal officers. How do we manage the litigation process? Do we continue to work as chief legal counsel as employees for the company? Or maybe do we have the company spin ourselves off and have our own law firm if we're planning bet the company litigation and have ourselves as outside contractors and outside attorneys? This is a discussion that I like to have and often do have. Finally, let me just close with a very timely comment. It couldn't be more timely because I think we're all lawyers, or many of us are accountants or financial professionals here, and that is the U.S. Supreme Court's agreement to take the case that arises in the context of a tax criminal prosecution called in re grand jury, if you're familiar with this. The question presented has to do with whether communication from the lawyer, which involves both legal advice and other stuff, whether that communication is protected from disclosure and discovery by the attorney-client privilege. Okay, this is a key issue for all of us, and there's nothing more important, I think, to any of us as attorneys than protecting the attorney-client privilege. Indeed, the attorney-client privilege is actually the oldest privilege, not only in the common law, but going back to the Roman law. Well, unfortunately, the Ninth Circuit Court of Appeals said that they denied the privilege in the context of this tax enforcement case because the communication that was involved was not the, quote, single primary purpose of the communication at issue. Well, I'm here to say that I hope, and I've collaborated with colleagues in 2 amicus briefs on this. I hope that the Supreme Court does not apply this very restrictive single primary purpose. And I hope that they do apply what I think is generally the rule right now, and that is whether the communication was, whether the attorney legal advice was a significant purpose in the communication. So please pay some attention to this if you're interested, if you're in an organization or an association and you can submit an amicus on this, it would be very good to do so. So at this point, I think I'll wind things up, and
Yeah, we're right
Thank
on
you.
time.
Thank you for
With
your
30 seconds
participation.
left. Thank you very much. Thank you. It's a real honor to share the stage with both of you, Dr. Ramm and Mr. Foster, and the roles that you played in history. Your role with the invention of the medical device, and your role around the large-scale litigation around the medical devices. So please join me in giving our speakers a round of applause. And we hope that you enjoy the rest of the Money 2.0, Law 2.0 program.